Finally, today, there was an interesting tech-related case that was argued before the U.S. Supreme Court yesterday. It involves a 1986 computer crime law that has been used ever since to prosecute hackers and internet activists and the like. People have been arguing strenuously that the law is outdated. And indeed, as Justice Gorsuch said in yesterday's court hearing, the U.S. government's interpretation of the law risks, quote, making a federal criminal of us all, end quote. And yes, if you're wondering, this is indeed the so-called Aaron Swartz law. Quoting Politico, the Supreme Court on Monday indicated serious reservations about the ambiguity and scope of the nation's only major cybercrime law, hinting it may narrow the law's applicability to avoid criminalizing acts such as checking social media at work. During arguments in a case involving a Georgia police officer convicted of violating the 1986 Computer Fraud and Abuse Act by accessing a license plate database, the justices pushed a Justice Department lawyer to explain how a ruling in the government's favor wouldn't open the door to prosecutions of innocuous behavior. Those could include browsing Instagram on a work computer or performing public-spirited security research to test a system for vulnerabilities. As the first CFAA challenge to reach the High Court, the Van Buren case generated amicus briefs from a wide range of technology, privacy, and cybersecurity experts, most of them on Van Buren's side. A group of cybersecurity experts described the CFAA as a sword hanging over the head of researchers who probe computers for weaknesses with the goal of helping their owners fix the flaws. The most controversial ever CFAA case never reached a verdict. In 2011, federal prosecutors indicted the prominent internet freedom activist Aaron Swartz on hacking charges for downloading millions of journal articles using a subscription provided by MIT. Swartz, then 24, faced 35 years in prison. He died by suicide in January 2013 while awaiting trial. The justices sounded alarmed Monday about the broader reading of the CFAA. Justice Gorsuch suggested that the Van Buren case was the latest example of the government trying to broaden the scope of criminal laws in contestable ways. Several justices expressed uncertainty about the definitions of key terms in the law, such as authorization, and they spent a significant amount of time asking both lawyers about the meaning of the word "so" in one part of the statute. Quote, what is this statute talking about when it speaks of information in the computer? Justice Samuel Alito asked, finding in at one point. All information that somebody obtains on the web is in the computer in a sense. I have a feeling that's not what Congress was thinking about when it adopted this law. I don't really understand the potential scope of this statute without having an idea about exactly what all those terms mean, Alito added. The justices also sought more clarity about the consequences that Fisher argued would result from a broad reading of the CFAA. Alito asked Fisher to explain how the CFAA would criminalize one of his example scenarios, lying about one's weight on a dating website. Fisher responded that by receiving interested messages from potential romantic partners based on a falsified weight, the user would be obtaining information from a computer in violation of the website's terms of service and also, thus, the CFAA. Similarly, Fisher told Justice Elena Kagan, checking Instagram at work constituted obtaining words and pictures from one's Instagram feed. And if a company prohibited social media browsing on work computers, obtaining that information would also violate the CFAA by contravening the employer's policy, end quote.